Good afternoon. I am Allison Mata, your host of Defense Diaries, and I am with you this afternoon with our continuing coverage of Indiana versus State of Indiana versus, hello, who am I here for? Richard Allen. Okay. And I'm bringing you our continuing coverage of the State of Indiana versus Richard Allen. As everyone knows, Bob Mata is in the courtroom, boots on the ground, and I am here with his notes. So today I will be giving you broad strokes because Bob's going to need to get into more details with his evening live as the defense called their neuropsychologist. So it started this morning with the defense calling Dr. Polly Westcott. She's 49 years old. She's a neuropsychologist. In 2004, all right, so I think that's when she got her doctorate, clinical psychology, neuroforensics. She works for both the defense and the prosecution. She worked with the prosecution on a case just several months ago. She's paid $4.50 an hour. She works on a lot of criminal cases on mental health issues, competency, to determine whether the person can determine what's real and what's not real. She also does mitigation. Judges also appoint her to do evaluations. She has testified 72 times, trial or deposition. She's extensive experience with prisoners, including Wabash Hospital, Women's Hospital, pretrial detainees, going and evaluating them. She's worked with law enforcement and crisis intervention and cognitive issues. She worked 12 years with the Indiana State Police. And then they put in Westcott's CV, was admitted and published as Exhibit FFF. In her daily basis, she has a clinical practice with patients and therapy and neuropsychology. 50% of her practice is, when she's appointed by a judge or an attorney or hired by an attorney to assess defendants. She gets into the difference between a psychologist versus a psychiatrist and explains how a neuropsychologist is sort of a hybrid of treatment and assessment. When she was engaged for Richard Allen, she did a mental health history, a neuropsychological evaluation, and offers an opinion on his health and I guess a description of what was going on. She reviewed medical records, pre-incarceration, post-incarceration, videos, treatment notes, and phone calls. This case, she said, was different in terms of volume. It was very atypical. She had 20 plus hours of video and just extensive volumes of information, everything from Westville to Wabash. March of this year was the last time she received information from the defense. She met Richard Allen in August of 2023. 2 hours of interviews, 6 hours of diagnostic testing. She administered tests. She went to the prison. He had made requests to speak with loved ones. At some point, he spoke with Kathy. There's some mention about missing some records. There was 127 pages of handwriting, maybe. Not exactly sure. She gets into Richard Allen's life. She says he has an extensive mental health history. He had intense anxiety since childhood. He was having intense fears that his family was going to disappear, intense fears of what other people think of him, thinks he's failing his family, he's failing his co-workers, severe depression as a result of his anxiety. He crumbles and he falls apart. talks about how when he was 40, 20, he started taking medication. He had 3 to 10 I think different jobs or years of jobs. Sorry, guys, this is why it's supposed to be broad strokes. So I'm going to try to be broader and not try to get into all of this. But his coworkers like him. He gets a promotion, but then bossing around people comes with severe anxiety. As he rises through the ranks, the pressure is really hits on him, and then the anxiety starts to rise, and that's like a vicious cycle. Diener asked some preliminary questions during the direct examination of the expert about the family history and about the medical records, and claims that it's hearsay. That objection was sustained. Now, that's very unusual. I mean, you always have experts that do medical or mental health evaluations giving history as part of their testimony. So, but the judge sustained that. She gets into him having a dependent personality disorder. He feels worthless without his mother and Kathy. He can't function alone, and he needs another person to help with decision making. And with prison, there was this fear of abandonment, that he's falling apart without his loved ones. She gave 6 conclusions. So she said that one was that he had a long history of mental illness. She used a fragile egg analogy, and talked about father abandonment issues. Then she got into how she did tests and assessment tools for malingering and to detect exaggeration, faking, or unclear reporting. It helps evaluate truthfulness. And she was looking for, consistencies in videos and other objective testing. She reviewed records, videotapes, audio cameras, and it was consistent with what she knows about psychosis, and there was nothing to indicate that he was faking. 3, as far as his cognitive condition, it had significantly slowed. So his thinking was slowed. His frontal lobe and problem solving was very low. He ruminates. He has trouble moving from one subject to another. Massive anxiety. Feels guilty prior to incarceration. There was self-blame there as well. Then she talked about how there was a distinction in his physical and mental health for the first 4 months. He had suicidal ideations. He slipped into psychosis. That he was drinking out of the toilet, eating feces, hitting or banging his head, hallucinating. So overall, she gives a diagnosis of major depressive disorder, and that's like when depression hits an all-time high, with psychosis. So major depressive disorder with psychosis and dependent personality disorder, anxiety, and then the final one was to kind of put all of them together: dependent personality disorder, major depressive disorder, anxiety resulting in psychosis. So that differs from just being psychotic, like that he's just psychotic. It's these other diagnoses resulting in psychosis. So she talks about some of the things she looked at. They put in as exhibit GGG the letter from November 9th, 2022, where Richard Allen asked the court for help and for that he needed a lawyer. So now you've got Diener asking some preliminary questions again. She asks, what's your experience? And do you have any experience in handwriting analysis? And the expert answers that it's part of her training. Differences in handwriting results from mental illness, to spot those things. So she was able to continue. Then they made the objection hearsay to get the letter in. They're just trying to kind of keep this testimony out. This defense argued that it was not being offered for the truth of the matter. It was just being offered to compare handwriting between the letter and between that written confession that he wrote to the warden. And that was April 5th, 2023, where he wrote that. Also, that they need to be able to demonstrate that there was a difference in cognitive ability between November of 22 and April, March, and June of 23. There was a lengthy sidebar, and then it was admitted over objection with redaction. So we get to find out, I guess, what those redactions are. Bob can let us know tonight. So she looked at the structure of the letter, the way that it looks, and explained why that's important. There was some spelling, like the letter, he spelled well, everything was well thought out, his thoughts were aligned, and it made sense. She found the samples useful because she noted changes in his handwritings between November and April to June. His signature looked different. There was no punctuation. There was not full letter construction. The writing looked different. So then they got an exhibit HHH, and that's a printout of objective personality tests. And they were analyzing for the presence of a personality disorder. And the test also covers malingering and personality factors. They made an objection, said that the defense never supplied the supplemental tests. Rossi said the state never deposed the witness. They could have asked the court to intervene. And that it looks like there were 12 assessment tools that weren't supplied. Looks like they let it go in because the next thing Bob starts talking about is her opinion of the MC and from the MCM1. There's no indication of malingering. Now, I'm going to let you guys know, I had a client once that went in for testing. It was in a civil case, but it dealt with mental health and his thought process and thinkings. And, I had an expert find that he was malingering, which, so these tests do, they do work. These are things that have been tested and are known to be able to pick up on this. And they're very objective. One expert can look at the other experts testing and say, wait a minute, that's wrong because X, Y, and Z should have added up to malingering. It's not very subjective based on my experience. All right, so then she gets into personality factors about how he's extremely dependent. He's passive. He avoids conflict and confrontation. He's quiet and he sticks to himself. There was also an emotional personality test and cognitive test that he is consistently looking for validation is what I think based on Bob's notes. So don't forget to catch Bob's evening update to make sure about that. So again, her opinion is that he is not resilient. He has stress, anxiety, and he's much more prone to decompensate and slip into psychosis. And he was having, it started like slowing of his thinking, then mumbling, then staying to himself. April through May, he was having psychosis. July through August, it was lessening. She's indicated that there were 30 different ways to examine feigning, faking, malingering, and there was, again, no sign or indication of malingering. Then they start to ask her if she's familiar with SMI. You'll recall that from earlier. This is what the defense says, that Richard Allen, upon going into the prison, had a significant mental illness as defined by the DOC, and that he should not have been allowed to be in solitary for more than 30 days. So the defense is asking their witness, are you familiar with SMI? She explains, yes, she worked in the prison system. She also evaluates pretrial detainees, and it's the clinical equivalent to the DSM-5, severe mental illness. And she said that Richard Allen fell into that category upon going into prison. They talked a little bit about Monica Walla's reports. She noted that something that caught her eye about the reports was that it wasn't typical to have quotes or narratives contained in a report. Again, Bob will have to give you some more details about that this evening. They talked about the effect of prison and being torn away from his family and support system. You know, that he was being in solitary, he had sensory deprivation, the lights were on, he's not sleeping for days, he had weight loss, he didn't have enough nutrition, people were calling him a baby killer and a child murderer, and because acceptance is so important to Richard Allen, he is like a sponge. So again, Bob will have to flesh that out for you some more, but it sounds like he's saying like he just really, all of this really impacted him and had an effect on him. She spoke about solitary and sensory deprivation, nutritional deficiency can all cause delirium. Now, the cross-examination by Diener, they get to talk a little bit more about sensory deprivation. That's where she starts out, and like she's that you know, whether someone can move around, if they're having contact with people. They talked about the liaison, although he can't see outside, he can't tell day from night. Then there was an objection about questions about daily visits, you know, Monday through Friday, 15 minutes to 1 hour daily. And then the question is, did you see the daily sessions? And she said no. She saw that there were, you know, a lot of notes and there were times in the notes, but that from what she recalls with contact, and I think this is what she's saying, that she would, you know, there were less that she would consider an actual session. So they talked about how the lights were on for his safety. The defense put, you know, was asking that they can be dimmed, that he had rec time, he could shower, his vitals were taken daily, and the expert indicated that there were many times that Richard Allen refused to leave his cell because he was concerned about his safety. She said she did not receive information from the defense about all of the facts, and there appears to have been some question like Satan killed the girls or something about Satan killed the girls that she did not know. Again, Bob will have to flesh that out for you more on the evening session. And then they probed her about how she would know if he was, you know, if he was telling the truth or not, if his confessions included accurate facts or not. And again, Bob will have to flesh that out for you. She said she didn't tell Richard Allen when she met with him that she was with the defense specifically. She just explained the process, and the limitations of privilege, and that he had the option to refuse. She talked a little bit more about dependent personality disorder, and that that's something that someone doesn't feel comfortable with strangers, and like you have an inner circle. So they pushed her on, well, with Dr. Walla, and this seems to be something that Alan must have said at some point, that he said, like, "You're like my wife, don't leave me," kind of saying, well, she was a stranger. If he's got this dependent personality disorder, why did he get attached to her? Why did he cling on to her? And it looks like she said that she did not opine that he transferred that dependency to Walla. But she talked about Richard Allen was seeing Walla a lot, you know, a lot. And, you know, she's taken all this in when she's forming her opinion. She was not aware of all of the facts of the homicide investigation. And again, she said that brief psychosis is not a DM5 classification. It hasn't been contained in the DSM since 2015. I'm not sure why the prosecution asked that, because it was their doctor that diagnosed brief psychosis. Or maybe they were expecting her to confirm that, yes, it was a DSM-5 classification. And she's like, nope, it hasn't been since 2015. They discussed the onset of psychosis being gradual. Um, and that, how do you know this? And she said, it's not the same reality we're living in. You've got disorganized speech as a symptom, not able to put together multiple sentences. Then they talked about, you know, how did you decide what to summarize and what not to include? And again, Bob will have to get sort of into that more, but it seemed like the prosecution was trying to say that they were piecemealing everything and they're not giving the jury a full picture. Um, and I don't know if she included a summary of the one about the van or not. She mentions that there was something with no quotation marks, so we'll have to see what Bob says about that. Um, there was an objection to the form of the question, and the witness indicated that her job was looking for mental health symptoms, trying to determine his mental state. Um, and again, Bob will have to go through this a little bit more because there's a lot of details. He can't write everything out, but she said that she did listen to phone calls where he said that he was losing his mind. Excuse me. And that was the end of the cross. But now we have jury questions, which I am very concerned about. So I don't know. We'll have to see because maybe Bob took them a different way. But the first one was, you stated Richard Allen had fears to leave his cell. Does this mean he had common sense to fake his psychosis? She says, great question. And her answer to that was that predated his psychosis. It was before April of 2023. So I just say I'm concerned. And yeah, look, it's good. The jurors, it was a great question. It shows the jurors are paying attention. But, it also showed that his mind went to, well, if he had fears to leave his cell, then he was kind of aware of everything. And he had enough of his senses to fake psychosis. But she dissuaded that by explaining that all predated his psychosis, where he was having those fears. It was before April of 2023. Now, this question, Bob will have to give you the answer because I'm shocked it was even read. Shocked it was even read, like that the judge decided it was a valid question to be asked. So here it comes. If someone has anxiety or mental health issues as a child, does that make them more likely to commit crimes? I'm shocked by the question because no one's saying that here. No one's saying that this guy. So is the jury trying to take, well, so because he had these mental health issues, does that mean he's more likely to commit the crime? That's why I'm saying the judge should have never even let that question, except I'm assuming that the answer was clearly no. I mean, definitely that was the answer. Just Bob didn't write out the full answer, so he'll have to get into it. But that question shocked me. That's like, what? I need to know which juror said that. Like, which juror asked that question? It is, I don't understand it. I don't understand what he's thinking or how he could think that. Then Diener follows up with, can you described him as passive, not aggressive. So I don't know, I don't know where that went. And then just like, there were some questions about what if he was not in a psychotic state. There were some questions about depression and anxiety as a child leading, then do you become a sex addict? I don't know. Bob's gonna have to tell you this question, but this is the other one this one was even worse. I was like, my head exploded. I was like, oh my God, somebody on there has synced into this sex addict. And I was worried about that when I heard it. Although I thought that the defense got enough out there to show that like, they don't even know if that was accurate, that he was a sex addict, or if he reported that he was a sex addict. And has he ever reported that before? Is that anything that's ever been, said? The answer to that was no. But now you know that at least one of the jurors is still hyper focused on whether that he said he was a sex addict to Dr. Walla. So somebody asked again for like the full diagnosis. Was her full diagnosis of psychosis? And she says no, he had severe depressive disorder with psychosis. That differs from being psychotic or just having psychosis. People with severe depressive disorder are 25% more likely to have psychotic episodes when confronted with anxiety. So she explains he was not diagnosed with psychotic. He was not psychotic. He had psychosis. So it was severe depressive disorder with psychosis. Then the question is, can objective testing be interpreted different ways? She said, I would say no. There's not much variation. There was some questions about whether his pre-arrest record contained objective testing. There's not an answer here, but I think it was no. And again, Bob will be able to get that to you. There was a question about if self-reporting scales are more subjective. Now, I don't understand. Again, you have to come back for Bob's evening update because the answer here was generally no. But I would assume that self-reporting is more subjective. So I'm not sure that I'm interpreting his notes, exactly right. That she was asked about the difference between delusions and delirium, with delusions being a false belief of something, and delirium being someone who doesn't know like who they are or where they are. And she gave a fun house analogy. Then we get into the in-cell videos, and they've got Max Baker back on the stand. He is the intern who works for the defense attorneys. So he was recalled. There was no audio. There were time, states, and dates. There was 20 hours of video. Defendant puts in 2 videos spliced, a couple of clips together. Or no, wait. So there's multiple videos, and Bob will go through the dates and times here. It wasn't 2, but it was a bunch of 5-minute clips put together. So he says that the male juror puts his hands on top of his head and puts his head down. He looks angry, visibly upset. Can't look at something. Another juror looks away from the screen. There's a bunch of videos, some other videos, some more incel. Now, McClellan says, isn't he safer? Are you trying to say he would be safer by himself? Or that someone was in the cell, is he safer to be by himself? There was an objection to foundation. He was asked how many times he had watched, how many hours he had watched. Bob will get into it, but it looks like 15 hours of movement video and 2 hours of in-cell videos. I kind of doesn't, I don't know if that's accurate, but he makes some sort of argument that you're trying to curry sympathy with the jury, that you picked the videos to show that shows him the worst, and you're trying to imply that Richard Allen was the victim. I don't know if there was some objections there, but that was improper. I think it's improper because, like to say that you're trying to imply that he was the victim. Now, it's different to say you're picking certain ones to curry sympathy with the jury. That's fair. But what you can see from this next question is why I think it was so improper. Richard Allen is not the victim in this case. Abby and Libby are the victims in this case. So Rossi comes back and says, well, did you pick the videos that show the truth? And then McClellan comes back again talking about how you picked 2 videos to show the very worst situations. And then it looks like Max said, you didn't have to object. As far as I recall, you didn't show any of the videos. Something to that effect. But then the jury question, this one horrifies me. You work for the defense. Did they instruct you on what videos you should review? Something to that extent. And Bob will have to come. You'll have to hear it from Bob later at where everything else went. That's the end of his notes. But I would note that the police and who picked which videos and which calls that they were going to play, did the jury not pick up on that? Especially where the defense is like, you only played 2 of the 3 calls that were made that day. And, didn't those calls have, he was asserting his innocence, and he was saying that he was losing his mind. But yeah, Max specifically said, as far as I recall, you didn't play any of the videos. So now I did just want to note that I don't know how long that they listened to the videos, and Bob will have to get through all that. So let's go through some of your questions. So Michael, hi, Michael. There are 2 arguments here: the confession as psychotic and the confession as a way to end torture, secondary gain as a way to end the torture. And I would, I guess, also argue that a confession was a way to, oh, that's what you're saying. Confession is from psychosis, or the confession as a way to end the torture. That's the secondary. And that's the way I look at it, is that. I'm sorry, I was thinking in my head that you're saying feigning psychosis to end the torture, but it's clearly not what you said. And my mind was just thinking of it differently. I agree with that. I think that secondary gain from the confession was a way to end the torture and a way to get more time, more phone calls, more access to his wife, stuff like that. And I also agree with Maced Mama. This is something that I've been dying to know. I thought the same thing. If he's a sex addict, you're going to see signs of that on his phone. That's not what they at least elected to show. They talked about him looking at scary movies and searching for a gun range and looking for what the darkest movies were on Netflix and the most effed up movies on Netflix. There was nothing about sex or nothing sexually related. Now, Richard Allen's wife, Kathy, will take the stand. I do not know I have no idea whether they would ask her if Richard Allen was a sex addict or whether she believes he was ever a sex addict. I don't know one way or the other. And I know Michael's in here. I just don't know. What do you think, Michael? Would you ask her that, assuming he's not a sex addict and that's never been an issue, and there's like that their sex is completely average? I don't even know that that's a way that she could get that on through the wife, but maybe. And thank you, Natasha, for becoming a YouTube member. Appreciate that. And Shannon, thank you for gifting a Defense Diaries podcast membership. All right, guys. Well, I think that's about it. Let me see if there's any other. Okay, Peaches. I hate to think this, but could they have gotten to the jury? I believe that happens. Look, I'm just gonna, I don't think anybody's gotten to the jury. It's just my opinion. This is literally just my opinion. I have no reason to think that. And I think that the jurors' questions are reasonable. It just scares me that they're thinking that way, but at least it's giving the defense some sort of insight. I know when I read the notes about him being a sex addict, I was like, that's not good. That looks really, really bad because it's starting to make him, you know, look like he might be the type of person that might commit a crime, or it was at least laying something, something, because that was in my mind always something that stood out, like that he doesn't have any signs of, like, you know perversion on his phone or violent watching violence, so the Google searches sort of touched on that. um So it's just they're asking fair questions, and I'm gonna just tell you, you have to, if you followed the Karen Reed trial at all, you have to know how hard it is to start to convince a jury that they're being lied to by police, that they're being lied to by prosecutors, that these people are, maybe if it's not being lied to, but that their perception is so tunneled that they're not getting, unbiased opinions from the police, from the prosecution. So, and Mandy points out that there was no previous sex addiction, or she asks, no previous sex addiction mentioned in his history. The only place I saw it mentioned is in Walla's notes. And Bob, when you come back this evening, Bob will be able to give you some better information about whether, about the question, the way it came up, and if the answer talked about her not seeing any signs of that. I don't know if she asked him that. I don't know if her tests touched on that. Would her test have uncovered that? And I don't know if that's something that the defense circled back to a little more in depth than the notes discuss. And Michael's saying 4:33 a.m. I'm not sure what we are talking about with that. Can you guys put up the question that Michael's answer went with? Or was it something I said, 4:33 a.m.? All right, well, I'll jump to this. So Charlotte's asking, is there even a definition of a sex addict? Is that even recognized? I believe that addiction is recognized. I don't know if it's in the DSM. Let me see. Sex addiction and hypersexuality are not included in the DSM-5, but if a person engages in sexual behaviors that causes distress, okay, so I guess it's not a recognized, diagnosis, but at the end of the day, it doesn't help that there's a kind of note like that. But I guess you're saying that maybe that's not something the expert would have come up on her objective testing, because it's not something that they test for, and I don't know the answer to that. Uh, but appreciate your question for sure. Oh, the phone connected at 4:33 a.m. I guess he's responding to what you guys are all talking about in the chat. Um, but I'm not seeing all of that right now. So 4:33 is when all of the messages flooded in to the phone, after having been off for some time, or not connected at some time, or not receiving messages at some time. I have to say, I have long thought this might have been a jammer scenario, that this might have been somebody using a jammer, and then the jammer leaves the area and then the phone comes back on. But that's pure speculation on my part. Um, but it's because it seemed to have happened so quickly It's like, how else does it happen that quickly and then still, it still come on? So Bowie Girl asks Allie, do you think the jury being able to talk as a group and discuss evidence will be detrimental to Richard Allen? I feel like the jurors get swayed before the official deliberations. That was my, initial opinion. I was outraged about it. I thought it defies everything that we're thinking of, and how could they be letting this happen? And I was very up in arms about it. And we had someone comment. It was somebody on the replay crew. I took a picture, um, and kind of mentioned the person before. See if I can find it now. But she made some very good points, and it harkened me back to, again, the Karen Reed trial, and that attorney Melanie Little and I, when we were on, we were talking about how hard it must be for the jurors to keep everything straight, because so much information had been, provided over time, and like their memory, that I would not be able to remember all of that stuff if I hadn't been talking about it on lives, talking about it with Bob, like reasserting like my position on things and reassessing things. I can't find the post now. I wanted to give a little shout out to the person and reread her post, but her comment was, that it really does help the people remember things by being able to talk about it, and that she doesn't, she really didn't think that it was going to be them necessarily, like, forming an opinion and staying in that opinion, as much as it would be just them kind of discussing everything and kind of remembering it. So I don't know where I stand. Again, like, my initial position was I don't like it. And I don't like it one bit. But then when I read that comment and sort of harkened back to my own position in the Karen Reed trial about the ability to even remember everything you hear, being so difficult. But I mean, I guess we'll have to see. And clearly, I'm assuming this is something, and Michael, you're here. Is this something that happens all the time in Indiana? This is standard operating procedure that the jurors, so long as they're all together, can discuss the evidence, as long as they're not forming an opinion, whatever that means. And we'll wait. And if Michael answers that, uh, Dizzy Mandy, if you can stick it up there for me. Debacle Watcher. Could EF have brought the phone back at 3:30 out of guilt and wanting them to be found? That's something that Bob and I have also both discussed. Not EF, whoever it is, who's ever involved, but that could they have turned on the phone at the end, um, because they wanted the girls to be found? And is that consistent with getting at least, Abby redressed because they wanted them to be found, and, they felt some remorse? I think it's definitely a possibility that it ended at that point and the people left, and before they left, they turned on the phone. Could be that somebody came back, and just to circle back, Michael says that it's not standard, but it is normal in Indiana. So, as far as letting the jurors talk, I also just wanted to speak out to any of our Defense Diary Patreons in here. I think that on the Patreon page, Darren put some uh, information about how to pose your questions so that they get starred and, um, placed in for me to read, whether or not it's a super sticker. Or do the same with members as well. Um, Obviously, we can't do everybody's, but that's supposed to be sort of a hierarchy there, that some members' questions get pulled for me to to comment on. All right, guys. Well, I don't know. There's nothing else. I think that pretty much covers everything for today, I do want to say that, you know, the I don't understand the state's position on why the van is such a big deal. I did look around on the interwebs and Reddit and everything. There has long been discussions about white van possibly interrupting uh, the perpetrator, that there was a white van on Route 625 at 3:30, that there was a white van parked by 625 between 1:30 and 3:30. And this is all years ago, years before Richard Allen was arrested and Richard Allen's confessions. But I just can't wrap my mind around how in the hell the state can say with a straight face that a man was interrupted at 2:27 and then got spooked, and then spent an hour and a half undressing, redressing, moving, positioning, covering with sticks before going back and being seen all muddied and bloodied at 3:57 p.m. It just doesn't work. It just doesn't make any sense. I think um, Michael asks, I can't keep up with the things as quickly as you guys put them are writing. So Michael asks, does the van open up third party guilt? I think the van opens up a lot of things. I definitely think it should open up third party guilt. It's like they need to just keep making the arguments again and again and again for all of these things. And there's so many things that I've thought of over the weekend that open the door to, you know, one thing or another. And, um, and I think it opens up, it was, Michael. It opens up them to ask again that the jury be taken out to the scene because Bob was out there. And no way, no how can you see that access road from various places, although it's hard to understand when the state is saying that he was scared. Because if they're sticking with this 227, then he's scared right when he comes down. Okay. And I can't remember if you can see the van from there. There was, I'm not sure, but Bob's going back out and looking at all of those things. But, um, and I agree, Michael. But the if that's the case again, he's scared at 227, so spooked. They walk through the water. He undresses someone. He's not going to SA her because he was already spooked. But then he undresses her and doesn't SA her, and again, then spends another hour and 40 minutes doing God knows what before being seen muddied and bloodied. So I think that they should go out there. I think the jurors need to see the area. They need to know where you can see things from and where you can't. They need to know how you can see straight across, when you're from one end of if you're on the high bridge and someone's, uh, you know, where either the clothes were or where they just need to see it all. They need to see it all. And I know that I don't know if Dizzy is saying that there was did they re-raise this issue today? Because I know before the defense withdrew their request to have the jurors go out and see the view the crime scene. So Diz, let me know what you're referring to, if that was a new request. Well, that's what I'm saying, Spitfire. I think yes, 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 yes. All of this has opened the door, and they should resubmit a motion, have the jury view the scene. That's exactly what I am saying. How does the defense get the van theory from true crime into evidence testimony. If the jury doesn't get to hear it, then they're left with the state's Hail Mary. I 100% agree. I expect or suspect that the state is the defense is working on that. I would anticipate, something. I just don't. It's not the easiest thing to do. If I were them, I would be asking for an extension and arguing that the state lied, they're being disingenuous, they're misleading the jury, and now they need, and this is because they said, I'm sorry, this is the part I mean. The state said, the state said to this jury and to this judge, this white van is the one thing only the killer knows. Anybody who has been following this case, who has been, I don't mean anyone following it, but those of you who are out in the, in the weeds of this thing, and you're following it on social media, and you've been part of like the groups who have been sharing information and trying to come up with leads and trying to solve this, you all know that has been talked about for years. This is not something only the killer would know. I think they need to ask for a continuance and address that however it needs to get addressed. Whether that be through a third party company, whatever it needs to be, they need the time to figure it out, and they need the grace and the leeway to do it, because the prosecution put that in issue, and they said it's the only thing, that only the killer would know this, only the killer would know this. Meanwhile, I don't know how many of you out there right now knew of this. Maybe we should stick a poll up here. Sleuths Investigates. Thank you very much. Allie, I listened to an old news clip of Mike Patty from 2/14/17 before the girls were discovered, and he said Libby sent a picture on Snapchat at about 2:30. That's very interesting. That's very interesting. So, but it was he could have been rounding up like the 2:11, wasn't it? 2:11? Or, oh, shoot. Out. They might be out, guys. They might be getting Bob. For the day here. So here's my suggestion to everybody here. Think about whatever questions may arise from what we've discussed, thus far, or or from the testimony, the broad strokes that I have provided you with, and prepare them, to raise with Bob, or Bob and I'm assuming I'll be there as well, for the evening live. And we'll readdress all of this, and maybe Bob will let us know, was anything raised? Did the defense ask for any time? Did they ask to have the jurors go out and see the crime scene again? Did they bring up the fact that this van was all over the place out there long before this? So we will see you in a couple of hours. Thank you for joining me. And please like and share. Got to get these afternoon lives out there. And don't forget, it is free to subscribe, and then you'll get notifications when I go live last minute, as I am always doing, because it depends when Bob gives me the notes. And then today what I did was I spent some time again, like I did the last time, trying to work out as much as his writing as I could, and so that I didn't come on here hemming and hawing about what everything might say, and figuring out ahead of time, all right, this is something that we'll just have to circle back with Bob, because the full picture isn't painted by the notes alone. So I appreciate it. Give us that thumbs up, like it, and I'll see you guys this evening. Thank you. Bye.